You go where?
Law school? What, like it's hard?
The rule for assault reads like this: an intentional act by the defendant creating plaintiff's reasonable apprehension of immediate harmful or offensive contacts to the plaintiff's person. To better understand this, we can break it down into 3 elements that you need to memorize and analyze for the exam. The first element is the act by the defendant that creates a reasonable apprehension in the plaintiff. Second is that there is immediate harmful or offensive contact to plaintiff's person. And the third element is the intent of the defendant. Let's go through each one to better understand how assault works. To satisfy the first element, reasonable apprehension means that the plaintiff has knowledge of the defendant's act and an expectation that it will result in immediate harmful or offensive contact to plaintiff's person. The plaintiff's apprehension must be reasonable. You should be aware of fact patterns that are designed to trick you by making it seem like the defendant is incapable of accomplishing the threatened harm. The apparent ability is sufficient enough to satisfy element number 1, so long as it could reasonably create the plaintiff's apprehension. The second element you must satisfy is the immediate harmful or offensive contact to plaintiff's person. Here, the important word is immediate. The plaintiff must apprehend an immediate or imminent battery. There cannot be a significant delay. This means that words or threats of future battery are usually insufficient to satisfy this element. However, if words or future threats are coupled with some overt act, like saying a future threat and then picking up a weapon, or the defendant clenches their fists indicating they want to fight, this may satisfy the second element. And lastly, the defendant's intent, which just means that the defendant acted with purpose or substantial knowledge that such contact was substantially certain to occur. You need to show this by using the facts given to you on the exam. The popular case on point is Cullison v. Medley. This is where the plaintiff, Cullison, met a 16-year-old girl in a parking lot and then invited her to his home for a soda, which she declined. Later that night, she and her family came to Cullison's home and surrounded him. They verbally threatened him with bodily harm if he did not leave the girl alone. The whole time, her father was armed with a holstered revolver. Cullison experienced mental trauma and distress as a result of the incident and sued them for assault. This case is a great illustration of words alone and future threats being insufficient to satisfy assault. The court had to decide whether or not the father, having the weapon on him while making the threats, made it rise to the level where reasonable apprehension was now satisfied. And the court said, hell yeah. Here's the court's analysis in the case. They said, assault occurs when one intentionally creates the reasonable apprehension of imminent harmful or offensive contact in another. It is a touching of the mind, if not the body, and as such, the damages which are recoverable are for mental trauma and distress. It is assault to shake a fist under another's nose, to aim or strike at him with a weapon, or to hold it in a threatening position, or to surround him with a display of force. Additionally, the apprehension must be one that would be aroused in the mind of a reasonable person. In this case, a jury could reasonably conclude that the Medleys intended to frighten Cullison by surrounding him in his trailer and verbally threatening him with bodily harm, while one of them was armed with a holstered revolver. Accordingly, the Indiana Supreme Court reversed the summary judgment on the assault count. And there you have it. Now you know the basics for assault. Let me know if you want more of this or more in-depth discussions on topics or cases. I'm just here to help. Don't forget to like and subscribe. It helps a ton so I can make more videos. Join us here at Law School Study Helper because, as you know, we're all in this together. See you next time.